Good afternoon, everyone. You'll see GoToWebinar's features include a questions drop-down where you can ask any questions you have during the program. We'll collect them all and answer either live during the webinar or afterward by email. Also, please note the orange arrow to the left of the control panel to minimize it, and the handout drop-down where you can download a copy of today's handout. Today's webinar, as always, is co-sponsored by the University of Florida Leaven College of Law Institute for Dispute Resolution. And now here's Rodney Max of Upchurch, Watson, White & Max's Center for National Class and Mass Actions.
Thank you, Kathy. I appreciate your introduction and welcome to everyone joining in. We have another amazing program that our firm and the Center for National Class and Mass Actions has been putting on for well over, I think it goes on into 3 past years. We mediate in 42 states around the United States, and we found it would be very helpful in raising the bar to the quality of class and mass actions to put on these webinars with an efficiency that, of being able to see them on the screen, but more importantly, with great panels like we have today. We're dealing today with 7 best ways to greenlight your class action settlement to a final approval. And with that subject, we have selected, and they have been gracious to be a part of it, are Bob Neary of Kozyak Tropin, Larry Silverman of Sidley, Ed Kilpela of Wade Kilpela, and Lance Harke of Upchurch, Watson, White & Max. We are going to be addressing some very poignant issues that are at the center of a number of cases that are in the appellate arena, Drazen versus Pinto being one of them, how to value non-monetary results, another, issues of reversionary structures, discussion of clear sailing provisions, as well as subclass issues that come out of class actions. So with that, I'd like to turn it over to Lance Harke.
Thank you so much, Rod. Thank you for taking the time to introduce us and introduce our great panelists. Someone a long time ago wrote that blessed are the peacemakers. And Rod, we're blessed that you are a peacemaker. So thank you for that.
Thank you for
everyone for joining. We have a fabulous panel. I want to give first a big thanks to a very close friend and colleague of mine, Professor Brian Fitzpatrick, who I'm sure many of you know and have worked with or have hired as an expert. He's my, he is a conservative legal scholar, probably my only favorite conservative legal scholar. And he, at the ABA presentation last year on class actions in Chicago, did a fabulous presentation on 7 red flags to your class action settlement. So, I thought, well, that's great, but there's a lot of negativity in the world. Maybe we can turn it around and make it green flags or green lights. So that's what we've done here. And so we'll just go through the topics a little bit. You'll see here the green flags that we're going to talk about in our hour are, non-monetary relief, questions of reversion, incentive awards, whether or not that's permissible or how do you deal with that now in the 11th Circuit, clear sailing provisions, conflicts of interest between potential subclasses in multi-state settlements, questions of class definitions, which deal with has everybody in your class been injured? Has someone been injured differently? And then, of course, the topic no one cares about, attorney's fees. So, we'll just start with the first one. Well, first we'll just go through these rules real quick, and feel free, guys, if you have anything you want to add as I take us through to the coupon section next. But as far as I know, Larry, none of this has changed, right? These are just the factors for adequacy that hopefully everyone on this webinar is aware of. Attorney's fees, the timing, Everyone has to be treated equitably. And then the question, our first tip deals with how do you value non-monetary relief? Fortunately or unfortunately, we did have a recent new opinion from the 11th Circuit, Judge Joe Flatt 90+ opinion that deals with a whole host of topics that we're going to be covering this afternoon. So Larry, we've allotted 4 minutes to discuss this 90-page opinion. Shoot.
Great. Well, thanks everybody. Drazen versus Pinto is came out last Monday, and Judge Joe Flatt wrote the majority opinion. That's the third Drazen versus Pinto 11th Circuit opinion that you've seen if you live in this area. One of the previous Drazen versus Pinto opinions was the one that knocked out incentive awards for named plaintiffs in class actions, and we'll get to that in a few minutes. But in the current decision, which is over 100 pages long, Judge Joe Flatt basically attacks every aspect of class action settlements and this settlement in particular. That said, if you take away one thing from this, is that 90% of that opinion is dicta. Judge Joe Flatt went off in a long decision about how there's a fiduciary duty of the plaintiff's counsel to essentially discuss the plus and minuses of the claim with the court as part of the process, and as to why they reached the numbers that they did. There's all sorts of items in there, but ultimately, most of that was not joined by the other two members of the panel. What the other two members of the panel did join was the question of, is your settlement a coupon settlement or not? And even as to that, it changed the analysis a little bit of what we frequently see in class actions, because we frequently see, and again, this is not an affairs, I'm a defense lawyer, but ultimately we always remember that that in order to have it takes two sides to have a deal, right? And so we always have to be sensitive that something works for the plaintiffs, something works for the defendants. And in this case, this involved a settlement involving GoDaddy, customers of GoDaddy who received texts way back before the TCPA was clarified by the United States Supreme Court and Facebook. And the settlement was you could either have one amount as cash or a different higher amount as a credit. And that's been fairly common over the years. Under the new 11th Circuit precedent, which is joined, that will be considered a coupon settlement. And why do I care about that? Because under the Class Action Fairness Act, if it's a coupon settlement, then the allocation and the question of what the attorney's fees are going to be isn't calculated till the very end of the case when we see what the redemption rate is. If it were just, I'm giving you $50 each, that could be a common fund settlement or a claims made settlement, but either way, the calculation of the attorney's fees would happen up front. By giving the class a little extra bump, you turned it into a coupon settlement. And so one of the first things that we're going to talk about as a panel is the question of non-monetary relief. You know, as always, you know, as a plaintiff, your first decision is what court do I want to be in? With the idea that depending on the kind of case you have, the question of am I going to be able to settle this at the end of the day under a manageable process, that goes into your first calculation. But ultimately, at this point, if you're in the 11th Circuit, you probably are not going to want to include a you know, any additional alternative credit that's an alternative to cash, because it will turn it into a CAFA coupon settlement.
And that's whether or not you value it for your fees. In other words, let's say everyone, you get a $10 coupon, but you know, I'm only going to consider the other monetary relief for my fee request. You know, I'm wondering, or maybe that hasn't been sorted out yet.
Larry, may I ask? And I'll apologize. I'm not as familiar. I'm not in the 11th Circuit, so I'm not as familiar. What was the notice process? Was it direct notice to all of the class members with this option, or was it a claims made process?
Well, again, it was both. The notice, the preliminary notice went to class members on an individual email basis. And because again, it's a TCPA case, they had your data.
They
right?
have it, right?
So they had it. So the notice went, but the question is ultimately, as we frequently see in class settlements, the attorney's fee petition will go out after the, in many cases, the motion for attorney's fees with amount and justification goes out after the preliminary notice. The preliminary notice will say, check the website or whatever, that's going to be up as well, depending on the settlement. Usually you'll see that there's an amount that they say, the plaintiffs will seek up to 5.3 million in fees or something like that under a motion, and all of that is scheduled for the following day. If you've got a common fund pool, and then all of that will be heard at the time, at the same time of the final hearing. In the dicta part of Judge Choflat's decision, he also criticizes that maybe the fee motion has to be filed before preliminary notice goes out.
Right.
So that was one of the things. And again, there's a vast difference between circuits on that point.
And some judges have already required it. Sometimes you could propose to the court a schedule where your fee petition comes in 2 weeks after your, motion is approved for preliminary approval, but the judge says, I want it early,
I mean, the fee, you always need to make sure your fee application goes in prior to the objector deadline. But I've never had a court required prior to notice going out. That's interesting.
For this opinion, it was interesting because it was a $35 cash award or a $150 voucher you could get. Like those are the two choices, and it was in the class. Actually, claims were kind of split almost 50-50 between people taking $35 versus people taking 150 vouchers.
Really?
And the opinion really said even if you're splitting it, they tried to argue, but this isn't a strict coupon settlement because people had the option to do one or the other.
Exactly.
And what the Choflat said was it doesn't matter. Like even if you're giving the person the option, if there's the coupon there, it's a coupon.
Was there a default if you failed to elect, you defaulted to one versus the other, or did you need to elect to participate?
You defaulted to cash. You defaulted to the cash.
It did.
Yeah. You go. I'm sorry. So half of this analysis is the question of whether you want coupons and what you want your cash to be. The other half of it, which obviously is a significant issue, especially for plaintiffs' counsel, is quantifying what injunctive relief you're going to get and putting a value on that so it justifies everything else. And so I think that's an interesting strategy tip for the plaintiffs' counsel on the line to talk about strategies in terms of bumping up the visibility and value of your injunctive relief.
It depends on what it is, right? So I mean, the paradigmatic example of where your injunctive relief is going to drive the value of your settlement would be a car defect case, where you get the manufacturer to agree to an extended warranty or free replacement of a defect that you've identified and litigated. And so there are people that have paid for it prior, right? So there'll be a small cash component going out to people that have had the defect manifest itself. But the real value is we're extending it to 100,000 miles in 8 years instead of 36 in 3. And you have to have an economist come in, and they will really take the value of the replacement, the value of the part, the cost of doing it on your own, and they'll give you a number that court, I've never done one in the 11th Circuit, but in the circuits I've practiced in, courts will always allow you to value the value of the case in your fee application off of that injunctive relief. It's more difficult, I have found, in consumer fraud cases about false advertising or things like that. That's a trickier thing to quantify, and for various reasons. But that's been my experience on the plaintiff side, and to value injunctive relief.
Right.
Yeah, I would say,
Ed, in California, don't many courts out there require you to? They want to see what that exact value is. What the precise value of that expert's mathematical computation and what it means exactly at the end of the day. before awarding fees, you know. Do you work with Jordan Lurie at all out in California?
I'm not working with him currently, but I know Jordan well. Yes.
A legend. We should have him on here next, but yeah.
You should.
But, right.
He would be able to speak. Oh,
This this is an AI generated distraction that will just
yeah,
take
I just got a notification. I am paying attention.
Yes.
Lance, to Ed's point, you know, and
This
as
is
far as keeping
one
with
of
the
those
theme,
efforts nowadays to indicate that you're human. You know, it's like red lights on bicycles on a capture.
you know,
We're,
Lance, kind of following up with Ed's point and, you know, and tips for Greenlight and settlement, you know, whenever we do injunctive relief, you know, in a case in our firm, that we always try to bring in an expert, no matter what it is, because it just helps with the, you know, to show the judge that
right.
give them something other than the attorney's opinion that this is worth money. Like,
We
so
could
you know,
easily
as far as
speak for
tips go,
hours
I would
just
always
with this.
suggest bringing in an expert on injunctive relief.
Like Brian Fitzpatrick, but yeah, on the valuing the relief for sure. We could speak forever on this case. I did, Bob, you brought up a good point. I just wanted to mention, I think Larry did too. You know, there are these, in terms of coupons, which has a derogatory connotation or used to, and then they became vouchers instead of coupons, you know, to make it seem less coupon-y now. But the question is, which shows like extreme couponing, you know, like you said, Bob, half of the class wanted coupons, right? I mean, so
Yeah.
what's wrong with a coupon? There are shows based about people who are insanely couponing.
You know, I think a piece of that, Lance, if you really think about it, is it may be a case by case basis, right? Because to me, it may depend on who you're suing in a sense. Like
Yeah.
if you're suing I don't know,
Coupon
for
for a
example,
car.
a pet store or something that you know the people are going to use, or they're a membership to Amazon
Right.
Prime or something
Repetitive, like you're always going to need rice or something, you know.
that you know people are going to reuse it. And that might be more, you know,
And
beneficial than.
the other issue is if you have a fee shifting claim, then it becomes much less important. Because if you're suing that there's not enough marshmallows in your Lucky Charms and you're filing under a state Deceptive and Unfair Trade Practices Act claim, it's not going to be a common fund. You're going to do whatever you're going to do, and you're going to get your attorney's fees on a lodestar. And whether or not there are coupons provided, you're not, you know, it's irrelevant what the redemption rate is because the fees are not measured on a common fund basis. So again, what we're talking about here is coupons in cases in which there is going to be the equivalent of a common fund for an attorney's fee calculation. If you don't have that, then this is much less of a worry.
Yeah.
Before we,
Sorry, Lance, one last point, you know, to Larry's point from earlier that, you know, CAFA now 1712 is where the coupon, you know, the fee part is, but it does, you know, it does allow you to kind of split your fee. If you also have injunctive relief there, other equitable relief, you're allowed to kind of base, you know, part of your fee on the redemption of coupons, part of your fee on the equitable relief.
right.
And I think it also includes a lodestar if you know, if you're thinking along those lines.
One last point.
Go ahead. No, I was just also going to mention quickly that for any sort of claims made or coupon settlement, there are courts now, most notably in California, that are holding back fees for a while, and then requiring you to give the court all sorts of notice about how much has been paid out, and then so you know, from a just practical standpoint, like your fee process can be held up.
And it probably, you know, in some circumstances should, you know.
Sure.
It's unfair to, in this context of non-monetary relief, to just focus on coupons, because you know, we all know if we've ever participated in a class action settlement, there, especially at mediation, there are significant injunctive changes that businesses do for which a plaintiff's lawyer should get credit at the end of the day for making their interactions with consumers better, you know. But it's like hot coffee. Everyone's going to talk about coupons, Larry. Instead of, you know. Let's keep going. Okay, reversion. This has to do with, money going back to the defendants from a settlement, right?
So starting with Judge Choflat addressed this a little bit, because the flip side of reversion is your class action settlement going to be on a common fund basis or a claims made basis? When a defendant says they're going to put 35 million up, is it 35 million or up to 35 million, depending on claims? In some courts, certainly if you're putting up 35 million, there's no question that the unused portion can't go back to the defendants. You're going to get, that's traditional conversion, reversion that is the subject of the challenges. The question, and then you're going to argue about whether it's cypre. Courts have different views on cypre. But we're seeing, and you have to decide, take a look at Judge Choflat's opinion as to whether or not claims made settlements or somehow fall into that barrel. Now, again, as a defense lawyer, sometimes, we almost always ask for claims made in the first instance in a negotiation. You ask, right? But we don't, depending on the claim, you don't get. Obviously, if you're a financial institution, I know the names of everybody, right? That's not going to fly in the long term. On the other hand, if I sold a product, and there's an issue where there's no ascertainability whatsoever,
Right.
then depending on your jurisdiction, it may even be easier to cypre 100% of it than to do a claims made settlement. You need to know what your jurisdiction is, because again, if claims made is going to be the same as reversion, where we're talking about a pool of up to X, and that's going to be considered reversion, which is a dirty word, then you need to go in an alternative direction. And so take a look at Judge Choflat on that. Again, that part of his decision is not binding, but an 11th Circuit judge said it. So there you are.
Yeah, and something Choflat said in his opinion was, kind of, why didn't they just pay the $35 to everybody? They knew who these people were. Like, why not just pay it out? But I think to Larry's point that, I think the courts are looking at reversions, as a red flag in a sense, that if you have that in there, and there's kind of two parts, right? It's either a reversion of the benefit maybe made to the class members, but then there's also the reversion of attorney's fees, in the sense that you're applying for an amount of attorney's fees, and if you have a part in your settlement agreement that says, if the judge doesn't award the amount we asked for, that goes back to the defendant. Courts also look at that as a red flag. So you should think about, if that's the case, putting in your agreement that instead of it going back to the defendant, it goes into the common fund for the class.
Right. I recall the days I probably participated in some of these settlements where it was either $35 in cash or $100 in coupons, or a voucher, or for repetitive service with a company where you're going to use it again, like a phone or it's not like you will use your internet next month, so why not? And again, if some people, it's not like Kellogg's invented, somebody just said, hey, let's put these little things in newspapers and see if we can get people to click them. There's a lot of science behind this stuff. It's an effective marketing tool that people like. So, that's my 2 cents on that.
On
That's
the
a lot of
reversion,
marshmallows in Lucky Charms, Larry.
I certainly think if you're going to do a reversion, like, you've got to be able to explain to the court in detail why that's included in your agreement.
And reversion is such a dirty word that even traditionally simple things like uncashed checks becomes an item of dispute. Like, what happens for the money that we funded where the claimant doesn't cash the check?
From a common fund where you have all this money, and people are, not everybody is as smart as the people on this panel and listening to us now, but some people don't cash checks. It's crazy, but they just don't,
And
I listen
to that issue. Oops, sorry, go ahead. Sorry, Bob.
No, you go ahead, Ed, please.
No, I was gonna say for that part, for me, it's always, your claims administrator is your friend here, right? Your claims administrator needs to do an affidavit or a declaration that goes to the court that explains to the court that there's no way that if we're sending checks out, every one of them is going to be cashed, and there is going to be some amount left over. And eventually it's too expensive to keep mailing out notice, and there's just a pool of money that's left. And explain to the court that this is going to happen, right? And I'm a big fan of Cypre. For my consumer fraud cases, there's the National Consumer Advocate Center, there's Impact Fund, there's Public Justice. There are groups that do advocacy and legal work in this space that we can direct it to. And I think for Cypre, to Greenlight, one of the things that you'll get an objector on is your Cypre is going to something that is completely untethered from your litigation.
Like
you
your
may draw an
lawsuit.
objector on that basis, right? So you need to make sure that your Cypre bears some relationship to whatever you're litigating against. So you can explain to the court that this is a benefit that this case will provide that goes to what this case is about. Because some judges will really scrutinize your Cypre too.
Can't be your law school in St. Louis anymore.
Exactly. Exactly. Your kid's school.
A couple of things on that Larry brought up about the checks that they're doing cash. I would say two. Well, one very quick anecdote is that I've had class members call me like 6 years later and say, listen, I just found this check in my desk. And this is really real money and thousands of dollars. And they're like, I'm wondering if I could get it reissued. And I was like, no, you can't. Sorry.
Here's another news flash. Some people are poor who get these checks and they move. So then, because the rent's expensive and they lose jobs, and it's America. So you got to find them. You got to skip trace it.
Yeah.
And
the other piece about that
is a dirty word, and it absolutely should not be.
Right.
But, yeah.
The other piece about it, as far as tips when you're settling, is I think nowadays you should always include choices for electronic payments. Because that way, and you put a Venmo, you put a PayPal there as your choice. If somebody still wants a check, they can select that. But to the extent that you have a Venmo, PayPal, the money's getting paid out as soon as they click that option. And I think there was a report by the Western Alliance Bank, who does class action conferences.
Great work. Yeah.
It said the vast majority of people actually prefer the electronic payments now.
They absolutely do. I use the Royal Bank of Nigeria. Okay, gentlemen, let's move on. Okay, this will just take a minute, Bob. Incentive award.
Yeah, so I'm 11th Circuit here, like Larry, and I guess all of us down here at least know of the Johnson case, which held that the incentive awards were going against the Supreme Court decisions from the 1800s. The good thing about it is that there's now been four circuits that have rejected that, and I think you have the 3 up here, Lance, but the 7th Circuit has also recently rejected. I think it was this year.
Yeah.
I have the site. It's Scott v. Dort, 99 F 4th 1076, but they've also recently rejected it. I think an interesting point to me about this is what's going on in the district, trial courts down here in 11th Circuit, is that enterprising kind of plaintiffs' attorneys have found a way to kind of still get something for their named plaintiffs, and kind of in 2 ways. One, potentially bringing like an individual claim in the complaint that's just based on your named plaintiffs' particular facts, and at the end during settlement you include a release for that claim.
Mm-hmm.
And that the courts are approving, in some instances, a payment for the release of that claims, or even if you don't bring the individual claim, just a broader release that the named plaintiff is giving than the rest of the class members are giving. And some trial court judges have been approving that. And if anybody's actually interested in it, and I think our emails are on this, I've been collecting all those cases myself, so you're feel free to give me an email and I'll send you along the sites.
Plaintiffs' lawyers can be smart sometimes. Larry, is that an okay solution? You tipped over the cow next door and you get it at the 10,000.
Generally, historically, our view was just don't do stuff that's going to draw an objection. Now, in terms of throwing me into the briar patch, if you're going to file a class action and include one extra weird claim for the named plaintiff, that would be awesome, because that gives me a typicality argument. as to, to fight in the first place. So I think the truth may be somewhere in between the two of those. So, but again, from the defense perspective, it is, I mean, traditionally it was begrudging, but that's not really our issue. And but don't do anything that's obviously going to draw an objection.
Ed, that you don't deal with this in the 11th because we're just strange in Florida, or what?
Well, I mean, I feel like this was a little bit like the Third Circuit's ascertainability opinion, that everybody held their breath and waited to see what other circuits were going to do. And thankfully, like ascertainability, it's remained confined to a single circuit. I think it's a problem. I think it's a problem for everybody. I mean, Larry and I were discussing this before we got on. Once you get the settlement, the adversaries like hold hands and then like begin to work together. And so everybody's interested in getting the settlement done. And this is an impediment, right? It's an impediment at the initial step where, I mean, it's known now, but in the 11th Circuit, there's a whole load of class actions that were on file when the Johnson opinion came out, where you now have to go back to your client as a plaintiff's lawyer and say, if it's a consumer fraud class action, that you were deposed, you've been working this case with us hand in hand for 5 years, and you're going to get $15. And it could be a struggle to get a class rep to ink that settlement because they're going to be upset that this happened. And so, I'm not surprised that there have been ways to try to figure out a way around the ruling, just because of the logistics and the real problems that you would have in dealing with a client who's going to be understandably upset that this was taken off the table, and they've spent a lot of time.
Understandably, I mean, I would just raise this also. I mean, isn't it unfair? I mean, shouldn't somebody who gives a deposition? I had a case once where Holland and Knight attorneys subpoenaed my client's computer in a case about a hotel resort fee in Jamaica. I mean, you sometimes have to do, your client has to do things and should get paid or somehow considered something for the effort, seems to me,
Right, or you've walked your client into a room where a skilled lawyer like Larry is going to question them for 8 hours, right? And that's
about marshmallow quantities.
It's unpleasant, right? It's being in a deposition is just unpleasant, right? I mean, it's they have to do it, and those of them that end up doing that, I agree. I mean, obviously, as a plaintiff's lawyer, I'm going to advocate for named plaintiffs receiving incentive awards because I see what they do and how much they help us. So I mean, I think there'd be a typicality problem, going back to Larry's comment, if it was something that was done on the way in, but on the way out, it's probably a smart way to do it. I worry that objectors are eventually going to come in. It sounds like an issue that a Ted Frank of the world is going to say, oh no, this is a massive problem. Now there's collusion in this way, and these people are benefiting the way they do.
Right.
There's definitely been some judges that have rejected it too, saying like this is just smoke and mirrors of you just getting an incentive award for your plaintiff. So it's really got to be something you can prove that it's a value that you're giving up for your plaintiff beyond what the other ones did. And just kind of in general, past the 11th Circuit's craziness, is that just incentive awards in general, like I usually when I'm asking for an incentive award in another court, I kind of try to make sure it's reasonable and equitable, for the class. And depending on what they've done, if it's an early settlement and they've done nothing, don't go out and ask for $25,000, for your rep. You got to be able to face what you're asking for and, why you're asking for that amount.
Indeed.
Know your judge, know your jurisdiction, right? What's been approved by that judge and what's been approved in that jurisdiction. Don't just come up with a number. Be able to defend it based on history.
Didn't judges, Bob, agree to? When this opinion first came out, Larry, I thought that some of these judges were agreeing to hold in abeyance based on full panel review, going back to the 11th again and again, and then if God willing, the law goes back to normal again, then you get your 10,000.
No, they were reserving jurisdiction while Johnson was on rehearing and Bach, et cetera, et cetera. But that's over. So no judge is going to keep a case open for administrative purposes to see if this ever changes as a result of an appeal of a different case. Not
Yeah.
gonna happen.
And the
Okay,
cert
well-
petition got denied too, so.
The good news is, it sounds like, before we leave this topic, that everyone on this panel agrees that the law of 1881 is the correct law, should continue to be the law of the land in Florida, and maybe should go national, you know?
Yeah.
So let's move on. Larry, you're a sailor. What is clear sailing?
Clear sailing is an agreement at the time of settlement that the defendant will not challenge the fee award of the plaintiff. Again, it is a usual and customary checklist item. And again, just to back up, we didn't talk about this at the beginning. There's two sets of objectors out there. That if you've got a class action settlement that is subject to the Class Action Fairness Act, it goes to your it goes to the world, and you may get objectors from professional objectors, and it goes to the state attorney generals. And so there's a checklist at some of the state attorney generals talking about reversion, clear sailing, where the defendant is not going to object. Now, obviously, it is more, I mean, it is less nefarious that the defendant has agreed to put up some amount or something like that. If it's specifically funded, I say we'll pay up to $5.5 million in attorney's fees in addition to the common fund. You know, then certainly I think there's more of a presumption that we agreed that we're not paying more than $5.5 million. You can cap it. But in
Doesn't
terms
the judge
of
have to carefully review and scrutinize the award before giving it to the plaintiff's counsel?
Well, again, ultimately, as a defendant in a mediation, the question is how much is our insurance coverage? What are we reserved for it? The fact that, again, whether the defendant is going to be paid adequately or not really my problem. But then on a separate level, if you've got a common fund with a fee amount of up to X, the defendant is agreeing not to object. Why? Again, what is that? That looks conspiratorial. Are you worried about the defendant objecting? In large part, some of this, I don't want to say honor among thieves, but if you've had a carefully litigated case, your opposing counsel, your opponent, you should usually be able to predict whether they're going to object or not. Right. And so in a great majority of cases, we seldom, if ever, which means we don't agree to clear sailing, but 99% of the time you didn't need it anyway. You know who we are. We know what we talked about.
Right.
So again, it is
that's a tough sell in a mediation. Everyone, no one's going to ask for more than 700,000, and but getting everyone on board with that without some comfort on the defense side that it won't be a penny over 700,000 is the reason for, and that's why they're there, it seems to me.
But again, we're talking about a cap, and if there's a true common fund, something like a financial institution that had everybody's names, we know this is a $10 million fund. Right. Period. And we know that you, the plaintiff, are going to seek up to 30% or whatever it is. I don't know your lodestar. I don't know, why are you, again, it looks bad. It is a traditional item of challenge, and it really doesn't get you anything in those kinds of cases, because ultimately you should know your judge, and you, as Ed said, you should know your judge. You should know what the prevailing number is, whether this is a 20, 25, 30, whatever the number is going to be. You should know if you've got the lodestar for it on a cross check or not, whether this is going to be a cross check required. But ultimately, requiring buy-in, from the defendant should be unnecessary. Other than the cap.
Bob, are you including those in your weekly class action settlements that your firm? Do you still see them? Do you need them, or
I think we do. Yeah, I think you do still see them, and I think kind of to your point that it's almost like it's been done for a long time. But I honestly take Larry's point very well. I think he's kind of right on that, especially in a common fund case. Like if you know your judge and you know that you've got you know, you can do a lodestar cross check that makes it reasonable. Like, why not just keep it out? I mean, to Larry's point, the defendants, they're given 10 million, and they're given 10 million, you know?
Right. We talked about this before we went live, but what exactly is the nefarious nature of it? It seems to me it's only if you are able to hoodwink the judge, you know, and in other words, if the judge has a role under Rule 23, you know, to analyze this fee request, and as a defendant, you just say, well, I'll just pay up to 10 million, you know, of this common fund amount of 30, you know, and if the judge approves it, how is that nefarious, you know?
I think Judge Choflat implies that it's a too quick a change from the adversarial position
But
that
that's
you
a
had
settlement.
to suddenly your best of friends, and you're dealing with a court that its job is as a fiduciary to police the fiduciary class person to make sure there's no collusion. And to have one of the people in the room, quote, bought off, that's the allegation that you'll see when there's a challenge.
Which one? To me, it's both. It's like the prisoner's dilemma I learned in philosophy class. You both have to be crooks equally, you know.
I think it's less of an issue for a common fund case. And to Larry, I mean, I think having been in a ton of mediations, as a plaintiff's lawyer, what the other side wants is to know what their outlay is going to be, right? The company wants to know, how much is this settlement going to cost me? And if it's a common fund, they know that, right? And so at that point, they're quite willing to let the judge determine how much of that common fund goes to the plaintiff's lawyers and how much goes to the class. It's different. You know, our first slide was about valuing the injunctive relief. And I do a lot of cases where there is a, you know, non-monetary component of the settlement that's going to be valued, whether it's a change in advertising or injunctive relief in the form of an extended warranty. And in those cases, when I'm in the mediation, the defendant always wants to come up with a clear sailing provision because they want to know, what is my fee request going to be, because they don't want to walk out of that room, have me walk into court and say, the value of my extended warranty is $200 million, Your Honor, and I want 50 million.
Exactly.
Right? Because if in the right court, they know I have a decent chance of getting it. And so they want to have a discussion about what's your lodestar. They want my lodestar number, and they want to come to an agreement on fees. And so it's very, so in that case, a lot of my settlements will have them. I think when it comes to presenting it to the court, I think it is a red flag. But I think it helps if you have a good mediator, right? A mediator that's known by the court, a mediator that can tell the court that, you know, I think this settlement is a good settlement. I think this fee request is a fair request, based on my experience and my history, and depending on who signs that statement, right? That is extremely helpful in that situation. But I have these. I'm settling a case right now with a clear sailing provision because the value, the value of the settlement's unknown. And they wanted to know what their fee exposure was going to be.
I think that some of it is the definition of the terminology. When I talk about clear sailing, I don't talk about the defendant not knowing what the number is, because part of that settlement is going to be that, you know, say it's a traditional settlement where the fee request is not going to come in at the same time as the preliminary approval, but you'll usually put something in the notice that the plaintiffs are going to seek up to X or whatever it is. So I should have an idea of that. This is more about signing away your ability to object to it. And that, you know, and you know, again, needing the defendant to sign that away. That's the mark that judges look at as potentially.
And that's a brilliant way of thinking about it, because like Larry and Bob and you all just said, if you're comfortable with your opposing counsel, which is a misnomer at the point you've reached a settlement, you're hand in hand, kumbaya to final approval, you know, you don't need it. You know, you don't need the defendant's comfort that it won't be in excess of X, you know.
The flip side of that is I view it as protecting my class members, which is my obligation. So if I don't have a clear sailing provision, even if I have a handshake agreement about the fees in the mediation, now I've exposed the people that I represent to a possible 3-year sideshow circus where the lawyers are just arguing about how the lawyers are getting paid up to a circuit court of appeals and back down. And that stops them from getting paid for years. And I've seen it happen. So I fully, and I think Larry's points are well taken and obviously well made. But I do think from a plaintiff's lawyer perspective, there is part of it that is protecting the speed at which the people you represent are going to get their money.
Right.
Yeah, Lance, the only last thing I would say on this is kind of to the point of what we have there on the slide, is that if you do have the clear sailing provision, kind of you want to make the court feel comfortable out as you can, that, maybe you have the mediator provide a declaration that you didn't talk about it until all the benefits were talked about at the mediation. You justify it with your lodestar, something that you can kind of show the court that, listen, this isn't a product of collusion. It's reasonable.
All right, guys, we've got 13 minutes to cover the rest of these. This has to do with multi-state settlements where you could have a group from a particular state who might have a claim that might be impacted differently, making or an objector saying I should this should be treated differently, this group, therefore there must be a subclass. You have a conflict within your representation of the entirety of the class. You must appoint a subclass for Arkansas, Vioxx claim. So,
from the defense perspective, again, as the plaintiff's lawyer, you're going to know your court, you're going to know your law, you're going to know if it's a TCPA case, with the minimum number of texts that you need in that jurisdiction in order to have standing. So you're going to design your class that way, that it's going to be 3 texts, not just 1 or something like that. But at a broader level, in the old days, and we were talking about this before the call started, in big class actions, you'd maybe try to value the percentages differently state by state. That in an antitrust case, some states have treble damages for indirect purchasers. Florida does not. So Florida would get a lower amount. That has changed a lot because of the much more active role of state AGs that will protect their state citizens. If you send out a notice where Florida plaintiffs are getting less, you're going to get a Florida AG objection. No, but again, that is, that they're big and they're bad, right? I say that with love. You don't want that. And so again, from a normally defense perspectives is how much money is this going to cost, but don't do anything that's going to draw an objection. And nowadays, punishing people in individual states will draw an objection.
Indeed, yeah, good observation. Has anyone else dealt with the G-men that Larry's talking about? The group of a gang of 7 state AGs that will contact you if they have an issue regarding your settlement.
I've dealt with them once where and it was a claims made settlement, right? Just because it was a consumer good that there was no record of who purchased it. So we had a long phone call with reps from about 6 or 7 states where they went through our settlement agreement chapter and verse and asked us a lot of questions. And then we had answers, and we never heard. They all they say at the end of it is, they never tell you, good to go. They simply say, thank you for answering our questions.
Oh, yeah.
We'll consider whether we're going to object. And you sit on pins and needles for months waiting to see what they're going to do. It's a lot of fun.
It's true Men in Black stuff. It's it's like getting a letter from the IRS or call. We've conducted our examination, and what happened? Did I pass? Do I owe money? What?
Right.
So yeah, I know that feeling. Thankfully, I don't anymore as a mediator, but yeah, it could be tough. Anything else on this before we move on?
Yeah, I have never dealt with the AGs. I think the subclasses was a big thing after that.
Job.
What's that?
Harley would handle the AG.
That's right. Yeah, but I think that, you know, the subclasses, I think, came around a lot because of the Amchin case back in the 90s, where the Supreme Court had said it needed to be subclass. But it seems to me that the courts kind of went away from it a little bit, that they don't really strictly follow Amchin anymore, as you can show that it's reasonable
Yeah.
what you're doing. I think the Second Circuit is still not great on it, if there's any circuit out there that's not, but
Well, like Larry has said, it's really the opposite. An antitrust, every antitrust victim, you know, has to be affected in the exact same manner. You can't have a subclass because it would arguably defeat your antitrust class, I suppose.
Well, you can to some extent, where you've got people, you know, cars would be different than trucks, or in a
Yeah.
case of employees that, you know, ex-employee is different. You'd have subclasses of different levels of employee, but things like that. But the question is, in the old days, part of it was distinguishing the benefits to the subclasses based on those state laws, and the AGs take that personally.
Well, it's not the old days any longer. Class definition. So I'm sure no one struggles with this when they settle classes. All of a sudden, Ed, you thought you settled one class, but the defendants want you to settle the 17 other ones for the same amount of money. You know, that never happens. Or vice versa, you know, the court scrutiny of a particular class definition, you amend the class to include other claims, you know, you amend to include other state claims for settlement purposes. You know, guys, talk in the few minutes we have about that.
Well, you've got to amend certainly the class definition, and the release, which is the flip side of that, needs to match up to the complaint. And that was a big part of Judge Choflat's decision, because those are the prior Pinto cases where the release was too broad. And so it's sort of two sides of the same coin. And, you know, that requires a degree of precision, a degree of rigor. You need to define the parties, you need to define, and then you need to make darn sure that your complaint covers it. And if not, amend the complaint. And, you know, we're not dealing with cases, we're not talking about today about whether there's dueling class actions, whether you're going to include in a class of somebody who's a kind of a competing class action where you don't have, you know, where you're competing with each other. But in any event, you know, the bare minimum is the precision to make sure that you're covered under the complaint. And
Right.
after the mediation, you know, we frequently see
the release, and it matches the release, the flip side, like you say, you know. Okay, anyone else?
I would just add that the real difficulty in changing your class definition occurs, and this happens if you're negotiating and the defendant proposes a slightly different class than has been certified. That's where it's a real nightmare. You can amend and change your class, but once that class is certified, that now you have a massive problem. And I've been in long negotiations where there's been a request to change your class definition and you can't, right? Like then now you have to move to decertify.
Yeah, and sometimes the defendant wants it narrower, you know, because they want obviously pay less. They don't think the claims on this other group is going to be as significant. They only got a text once, Larry, or, you know, that kind of thing. Yeah,
and so that in those cases that Ed noted, frequent we'll see if there are multiple cases, say you've got a main case, but there are also other ones, you'd amend the complaint in that class, in that case, which doesn't have the certified class, and then you can combine them together. You know, that
100%. Right. There are ways around it, but it's a nightmare. Yeah.
The other thing to keep in mind is if you do certify before you settle, and you know you change the class definition, is that you want to have to renotice if it's a broader class to send out to.
I think Joe says even if it's the same class, you have to renotice.
Even if
they talk about giving multiple opportunities to opt out, which no, I mean
he's really protecting the little man.
No.
Yeah. Okay. Well, this is like the SNL skit with Lindsey Buckingham. Sorry, we have no time for our final guest, attorney's fees. Quickly, guys, give us your thoughts on attorney's fees.
it used to be, it's gotten much more, there's a lot more scrutiny now on plaintiffs' lawyers. Keep your time, keep it carefully, and recognize that a judge may go through your time line by line. And really, particularly in certain jurisdictions, Northern District of California being the one I think of the most when I'm talking about this, but your time is going to get scrutinized, and you're not just going to be able to file some sort of summary declaration. And if you don't keep accurate time while you're doing it, you are going to have some issues. So just be very careful.
Yeah, just to follow up on Ed, we kind of talked a little bit about fees throughout, but just whatever you can do to support it, the Lodestar cross-check. If you're valuing injunctive relief, have an expert, possibly have an expert on your reasonableness of your rates. And again, knowing your judge, knowing your district, but you want to give the court enough information, or as more than enough information to support it.
An interesting twist is for just now as a mediator, you see, the aggressive, you're opposing counsel once you've reached a deal. Now you're joined and you're working forward. But in the time when you're still aggressively litigating against each other, you might ask when you're making tell me your hourly rate. How much have you billed on the other side? But you have 4 million in fees, so why can't we get 4 million as a plaintiffs group? But then that changes. Now when you make the application, you're going to be judged by the court standard of what attorney fees should get paid in that area, and all that other stuff, right?
From the defense perspective, you're negotiating, so you want to understand, like in negotiating 101, what are the incentives for my adversary or opponent? What are their issues? And plan for that. We expect attorney's fees as a component to it. We understand. And so don't necessarily agree. We're not volunteering, but you'd be a terrible lawyer if you didn't understand what the others, what the position of the other side was, and what the law is, and what the prevailing rates are. And, like I said, but ultimately, the goal is to reach, you're the mediator, is to reach a deal that requires everybody to understand and have the circles overlap.
Well put. Yeah, my one of my mentors in the class action practice, Ben Barnow out of Chicago, used to say everybody, defense lawyers, plaintiffs lawyers, the class rep, everybody should get compensated for the work that's good that they do for this resolution, which presumably brings some positive value, at the end. So, that's how I think I try to keep it in mind. I wish judges would agree, but that's it. Anything else before we break, Kathy? And you want to close us out with anything? Thank you all for joining. It's been a pleasure to have this fantastic group of wise class action litigators who have seen it, who shared their wisdom and experience, the kind you don't get in books or in law schools. So thank you for doing that. Kathy, anything else before we leave? Here's the bar information for the Florida Bar. The bar course number is 240-33687.
Let me read that out for you. It is 240-3368N as in Nancy. Again, 240-3368N. Attorneys in other states will want to check for our follow-up email on Friday. It will provide details on obtaining continuing legal education credit in Alabama, California, Georgia, Illinois, New Jersey, New York, and Texas. We're building our webinar schedule for the remainder of the year, so please watch your email inbox for news about our future programs. And on this slide, you'll see contact information for presenters and technical assistance. And thanks, Lance, and everyone else.
Thank you all. Thank you, guys. Grateful. Thank you
guys
everyone for participating and attending, most especially. Have a great day.
Thank you.